let's just get closer to Dr. Justice Shemsai and get some response from him as far as this particular case is concerned. The fact that the case has come up and then the court is just around, and then we'll pretty shortly we'll engage him so that he gives us some perspective about what has happened and what we should be looking out for, especially also because next week the parliamentary candidate elect would be sworn in parliament, just so because they take their seat before the president-elect is also sworn in at the Independence Square. So submissions made today have been very, very interesting. The copious legal submissions have been made, authorities have been cited, and of course the court's attention was drawn to precedent-decided cases and what a court ought to look at to be able to come to a firm determination in relation to that. Earlier, a preliminary legal objection against the hearing of the mandamus was refused, was overruled, because the court was of the considered view that there should be another avenue, of course, especially so if the election has not already been gazetted or been published in the gazette. There should always be that platform for an aggrieved candidate to raise issues or to file an application to seek for judicial review in the nature of mandamus. So clearly the law court complex has been very busy. The parties are here. Ibi Bright was present, Rabina Obin was present, Baba Siddiq was also present here, except Mr. Christopher Beyer was also present in court. So all of them have come up in court and they have made their points clear to the court, and the court will now have an onus to make a determination in respect of this very case on a Saturday. So clearly the case has come up, and as you can see behind me, a lot more people have come to the court to make their voices here, to lend support to their respective parliamentary candidates in relation to this very matter. So if you look at what is happening now, it looks clear that all of them will have to go and make their way back to the court sometime on Monday or Saturday, I beg your pardon, Saturday, January 4, 2025, where the court will be making submissions. So as you can see, few people standing around looking at what is happening and also having conversations around. And so pretty shortly we'll engage Dr. Justice Shemsai, senior law lecturer and also a private legal practitioner who has also been monitoring this case throughout from the morning up to this time of the day, so for some perspective and for some appreciation. The police has also not been left out. The police have also made their presence felt here at the court, and they were here to ensure that whatever processes that or whatever activities that are taking place, lives are saved, properties are protected, and everybody lives here in harmony and without any issue at all. So clearly that was the reaction, or that was how the situation panned out here at the law court complex here in Accra. So that is what it has happening here. So let me just get closer to Dr. Justice Shemsai, who has also been in court right from day one. He seated, monitored whatever was happening, and he gave us some perspective as to what exactly has happened. Now, you were in court, you heard argument being made in respect of each of the constituencies. First of all, with Sama Central, you heard the argument that were made. Submissions were made, videos were played in open court. From where you stand, what does it mean to the case before the court, really?
So the Tema Central issue is one of whether or not there was a declaration. I think that was the main thing. And you will see, I think on the 13th, the EC issued a press statement concerning the collation that was happening at the police, police training school. And the EC itself called it a recollation. And in that, you see that the video played showed that there was a declaration of the result. Now, the petition or the applicant's concern was that the declaration was not proper. But that obviously is not a question for mandamus to be. It requires a certiorari. If you allege that something was done improperly, you apply for it to be quashed, not to ignore it and then issue an order for a different thing to be done. That was the fundamental flaw in that particular case. But the other issues are that for mandamus to be, granted, you need to show some things. One of them is that there's a statutory duty which is expressly stated in law, there must be a demand that it should be performed, and there must be a refusal that the demand will not be performed. Clearly, there is no evidence that there is a statutory duty called recollation. Once collation is done, the next thing you do is to challenge it by way of what? Election petition. But there's nothing like recollation. That has been our argument. Secondly, there's no evidence. All we saw was that a letter purported to have been submitted to the EC.
In respect of those letters, what exactly are the letters supposed to confirm before an action of this nature is initiated?
Yes, so those letters are supposed to first indicate that there is a statutory duty, and secondly, that they are demanding that the duty be performed. And the EC should have responded or replied to the letters to say that I will not perform it. Then the course of action for mandamus would come to exist. In this case, there is no letter from the EC indicating that they are refusing to perform those functions. And indeed, if you look at the posture of the EC during the proceedings, you could see the readiness to perform the duty. So then the question we ask is, why come for mandamus if all you want is for the EC to perform a duty, which they are willing to perform anyway? What is holding the EC? But that is why they are not telling the court the whole truth. They are proceeding on the assumption or on the falsehood that there were no collation, and that was the argument of the applicant. They were saying that there was no collation, but of course, thankfully, because of technology and video, we have all seen those collations being done. We have all seen the declaration being done. Their problem is that the declaration was not proper. It was not in compliance with law, and our position is that if that is your concern, then
one of the point that you indicated was that this very mandamus application was defective in nature and it was incompetent based on grounds that you felt that a declaration have been made, and so if there's anything, you should come by an election petition. The court disagrees with you. The issue about threat and duress and coercion, how does it play in this whole matter?
No, we think that those are serious allegations. Threats, use of force, fraud, those are significant allegations. And even in normal civil rates trial, if you allege such things,